Friends, in the first part of my lecture on amending power of Parliament, I have analyzed the nature and scope of the power, and in this lecture I am going to consider whether there is any limitation subject to which the Parliament has to exercise its power, and what role the Supreme Court has played in determining the scope of the amending power under the Indian Constitution. Constitution of India, as we all know, did not expressly provide any limitation on the power of amendment under Article 368. The constitution makers did not think it necessary to provide rather for any alternative procedure such as a referendum or a new constituent assembly for amending the provisions of the constitution. Therefore, under the Constitution of India, a constitutional amendment should be considered valid, provided the prescribed procedure is followed. However, after independence, leaders had started to take some measures to bring some economic and social changes in the country. In a country like India, where the land was concentrated in the hands of a few landlords, the government found it as necessary to carry out agrarian reforms to ensure equitable distribution of land with a view to put an end to the land tenancies in the agrarian sector. And this was actually the mandate of the constitution also. After independence, various state legislations relating to land reforms were enacted for this purpose in India. However, such legislations were challenged before many high courts. This led to a series of amendments to the Constitution of India to give blanket protection to the state legislations relating to the agrarian reforms. In order to overcome the verdict given in the case of Kameshwar Singh versus State of Bihar, and to carry out the agrarian reforms in the country, Parliament in the first instance brought First Amendment by which they added Article 31A and Article 31B read with the 9th schedule to reduce the power of judiciary to question the constitutional validity of the land reforms legislations. Thereby, Article 31B and the 9th schedule made controlled constitution into uncontrolled one. Validity of the very first constitutional amendment was challenged in Shankari Prasad versus Union of India in 1951, mainly because it had inserted the 9th schedule to insulate agrarian laws from being tested in courts. The issue of facing the Supreme Court was to determine the extent to which the Parliament could go while exercising its amending power under Article 368. The argument against the validity of the First Amendment was that Article 13 prohibits enactment of a law infringing or abrogating fundamental rights, that the word law in Article 13 would include any law, a law amending the Constitution, and therefore the validity of such law could be judged and scrutinized with reference to the fundamental rights which it could not infringe. Adopting the literal meaning of the Constitution, the Supreme Court upheld the validity of the First Amendment. The court rejected the contention and limited the scope of Article 13 by ruling that the word law in Article 13 would not include within its compass a constitution amending law passed under Article 368. The court held that the terms of Article 368 are perfectly general and empower Parliament to amend the Constitution without any exception. The fundamental rights are not excluded or immunized from the process of constitutional amendment under Article 368. These rights could not be invaded by legislative organs by means of laws and rules made in excess of legislative powers, but they could be certainly curtailed, abridged, or even nullified by alterations in the Constitution itself in excess of its constituent power. The validity of the Constitution 17th Amendment Act of 1964 was called into question in Sajjan Singh versus State of Rajasthan in 1965, and this amendment again adversely affected the right to property. By this amendment, a number of statutes affecting the property rights were placed in the ninth schedule and were immunized from court's review. It was noted that Article 31A and Article 31B were added to the Constitution, realizing that state legislative measures adopted by certain states for giving effect to the policy of agrarian reforms had to face serious challenge in the courts of law on the ground that they contravene the fundamental rights guaranteed to the citizens by Part 3. The court observed that the genesis of the amendment made by adding 31A, Article 31A and 31B is to assist the state legislatures to give effect to the economic policy to bring about much needed agrarian reforms. Next, the Supreme Court in Sajjan Singh case actually ruled by a majority of 3:2 that the pith and substance of the amendment was only to amend the fundamental rights so as to help the state legislatures in effectuating the policy of agrarian reform. The conclusion of the Supreme Court in Shankari Prasad case as regards the relation between Article 13 and 368 was reiterated by the majority. It felt no hesitation in holding that the power of amending the Constitution conferred on Parliament under Article 368 could be exercised over each and every provision of the Constitution. In I.C. Golaknath versus State of Punjab, that was in 1971, the constitutional validity of amendment relating to property, namely First Amendment of 1951, Fourth Amendment of 1955, and 17th Amendment Act of 1964 were again challenged, and Supreme Court was asked to reconsider its earlier decisions in Shankari Prasad and Sajjan Singh cases. The validity of the Punjab Security of Land Tenures Act 1953 and of the Mysore Land Reforms Act as amended by Act of 14 of 1965 was challenged by the petitioners under Article 32 of the Constitution. Since these acts were included in the ninth schedule to the Constitution by the Constitution 17th Amendment Act of 1964, the validity of the said Amendment Act was also challenged in this connection. And in this connection, it was urged that Shankari Prasad's case, in which the validity of the Constitution First Amendment Act of 1951 had been upheld, and Sajjan Singh case, in which the validity of the 17th Amendment Act 1964 had been upheld by this court, it was held that it had been wrongly decided. It was contended that Parliament had no power to amend fundamental rights in Part 3 of the Constitution. 11 judges participated in the decision and they divided into 6:5. The majority now overruled the earlier two cases which we referred above and held that the fundamental rights were non-amendable through the constitutional amending process under Article 368. It has held, among others, firstly, that Article 368 only provides for the procedure to be followed regarding amendment of the Constitution. The power to amend the Constitution is derived from Article 245, 246 and 248 and entry 97 of the Union List. Then the expression law as defined in Article 13(3) includes not only the law made by the Parliament in excess of its ordinary legislative power, but also an amendment to the Constitution made in excess of its constituent power. Then it was also held that an amendment of the Constitution, being a law within the meaning of Article 13.3, would be void under Article 13.2 if it takes away or abridges the rights conferred by the Part 3 of the Constitution. Next, the Constitution First Amendment Act of 1951, the Constitution Fourth Amendment Act of 1955, and the Constitution 17th Amendment Act of 1964. It was held that they abridge the scope of fundamental rights and are therefore void under Article 13.2 of the Constitution. Next, it was also held that the Parliament will have no power from the date of the decision to amend any of the provisions of Part 3 of the Constitution so as to take away or abridge the fundamental rights enshrined therein. On the application of the doctrine of prospective overruling, the decision of the court will have only prospective operation, and hence aforesaid 3 amendment acts will continue to be valid. In effect, the majority judgment given by 6 judges overruled the unanimous decision of 5 judges in Shankari Prasad and majority judgment of 3 judges in Sajjan Singh. In order to nullify and supersede the judgment of Golak Nath and to provide unlimited power to Parliament to amend any part of the Constitution, including the fundamental rights, the 24th Amendment Act of 1971 was enacted. Along with the Constitution 25th Amendment Act 1971 and the Constitution 29th Amendment Act 1972 were also passed. The 24th Amendment expressly empowers the Parliament to amend any provisions of the Constitution, including those relating to fundamental rights. Amendments were made to Article 360, and the article was given a new marginal note, that is, power of Parliament to amend the Constitution and the procedure therefore. Then a new clause was added as Clause 1, which stated, notwithstanding anything in this Constitution, Parliament may in excess of its constituent power amend by way of addition, variation or repeal any provision of this Constitution in accordance with the procedure laid down in this article. And another clause 3 was added, and it provided nothing in the Article 13 shall apply to any amendment under this article. Another amendment to the old Article 368 made it obligatory rather than discretionary for the President to give his assent to any bill duly passed under the article. The Constitution 25th Amendment Act 1971 amended the provision of Article 31 dealing with the compensation for acquisition of properties for public purposes, so that only the amount fixed by law need to be given, and this amount could not be challenged in the court on the ground that it was not adequate or in cash. Further, Article 31B of the Constitution, Article 31C was inserted. Article 31C provides for saving of laws giving effect to certain directive principle of state policy in Part 4 against Article 14 and 19. The 29th Constitution Amendment Act of 1972 amended the 9th schedule to insert therein 2 Kerala Amendment Acts. The validity of 24th, 25th and 29th amendments were challenged in the landmark case, that is the Keshavananda Bharati versus the State of Kerala in 1973. The main question involved was the extent of amending power of the Parliament under the Article 368 of the Constitution. This case dealt with some of the most important questions ever raised in the annals of Indian constitutional law. They include, first, whether the Parliament can abrogate fundamental rights enshrined in Part 3 by exercising amending powers under Article 368. Next, whether amendment under Article 368 is law under Article 13. Next, what is the width and the scope of amending power under Article 368 after the 24th Amendment, and whether the same is to be excised subject to basic structure of the Constitution. Whether there is a distinction between constituent and amending powers. Constitutional bench comprising of 13 judges unanimously upheld the constitutional validity of the Constitution 24th Amendment Act 1971 and in doing so overruled the prior decision of the Supreme Court in Golaknath's case and cleared the way for upholding the validity of the other Constitution Amendment Acts, which were questioned before the special bench in the writ petition. The majority decided to adopt the position that amending power of Parliament is distinct from legislative power and has a wide reach to cover every provision of the Constitution. However, it qualified the above proposition by laying down that the basic structure of the Constitution was unamendable. While formulating the notion of the basic structure, however, it was clarified that what features would become the part of the basic structure would be an open question and its answer would be contingent upon the particular circumstances of the actual cases. On the other hand, the minority by and large approved the views of minority in Golaknath's case. Of course, it also categorically held that the amending body does not have the authority to effect complete abrogation of the Constitution in one stroke. Subsequently, the Constitution, after this Keshavananda Bharati decision, the Constitution bench in Vaman Rao versus Union of India in 1981 held that amendments to the Constitution made on or after 24th April 1973, inclusion of various acts, regulations therein are open to challenge on the ground that they or any one or more of them are beyond the constituent power of Parliament since they damage the basic or essential features of the Constitution or its basic structure. But subsequently in the decision of Minerva Mills Limited versus Union of India in 1980 and Bhim Singh Ji versus Union of India, it was observed that judgment in Vaman Rao needs to be reconsidered by a larger bench and that if any act, rules or regulations inserted in the 9th schedule is found to be violative of Article 14, 19 and 31 can be included in the 9th schedule or whether it's only constitutional amendment amending the 9th schedule which damages or destroys the basic structure of the Constitution that can be struck down. Finally, in I.R. Coelho versus State of Tamil Nadu, a 9-judge constitutional bench of the Supreme Court held that all amendments to the Constitution made on or after 24th April 1973, by which the 9th schedule is amended by inclusion of various laws therein, shall have to be tested on the touchstone of the basic or essential features of the Constitution as reflected in Article 21, read with Articles 14, 19 and the principle underlying them. To put it differently, even though an act is put in the 9th schedule by a constitutional amendment, its provisions would be open to attack on the ground that they destroy or damage the basic structure of the basic structure. If the fundamental right or rights is taken away or abrogated, pertain to the basic structure. The Supreme Court further stated that if the validity of any 9th schedule law has already been upheld by this court, it would not be open to challenge such law again on the principle declared by this judgment. However, if a law held to be violative of any rights in Part 3 of the Constitution is subsequently incorporated in the 9th schedule after 24th April 1973, such a violation shall be open to challenge on the ground that it destroys or damages the basic structure as indicated in Article 21, read with Article 14 and 19 of the Constitution. Finally, in I.R. Coelho's case, the Supreme Court has rightly concluded that the Parliament's power of amendment is subject to judicial review of courts. The court emphasized on the doctrine of basic structure theory propounded by it in the famous Keshavananda Bharati's judgment while adjudging the validity of amendment. So with this, I conclude this lecture. Thank you.